This is case number 21-171-768. This is Auto Club Group versus Deandra Field and Cedric Fields and Leandra Lucas. The matter is before the court. Looks like it's set on for a review hearing. Your appearance regarding the Auto Club, if you will. Auto Club Group, please, your appearance. Any counsel for Auto Club Group on this Zoom? All right, looks like, just one moment. This is set for.
That's the
10 o'clock.
yes, you talking Ms. Lucas?
Yes, I
Yes,
see
you
something
said
over
that.
there, but I don't see the plaintiff's counsel, so.
Oh, they probably, yeah, it's set for, I think.
All right, I'll call that matter again. It's set for 10 o'clock AM, so I'll come back to that matter in just a moment. All right, the court at this time is calling case number 21-166-461. This is Kevin T. Crawford, DO, PC versus City of Detroit. The matter said before this court. Looks like the court's adjourned a review date until today's date. Your appearance for Crawford, please.
Joseph Falls on behalf of the plaintiff, Your Honor, P800521.
All right, thank you, and good morning to you, counsel. For the City of Detroit, at this time, you may enter your appearance, please.
Good morning, Your Honor. Gregory Pattison, P75963, here on behalf of defendant, City of Detroit.
Thank you, Mr. Patterson, and good morning to you as well, sir. All right, so somebody update me. I know I said it over for a review. Somebody update me on this matter, please.
Yes.
We have,
Oh, go ahead, Joe.
I was gonna give you some good news, Your Honor. We have a settlement through the bill date of January 20th, 2021. Sorry, January 2022. And we'll have the paperwork to you hopefully within the next week or so. At least the dismissal.
Yeah, Joe, would you, or actually, I'm sorry, Judge, would you prefer we simply do a dismissal without prejudice while we handle all the settlement and get that through? I do think City Council is going on recess, so it may be a little bit just so we don't have this hanging out there. I just think procedure that might be the cleanest way to go, but I will certainly defer to the court in that regard.
Thank you. The court will issue its order that will indicate that the matter is dismissed without prejudice, contingent upon the satisfaction as set forth on this record. And when the settlement is approved and funds dispersed, the dismissal will automatically become a dismissal with prejudice. I will generate such an order. You'll receive that in the next couple of days.
Thank you, Judge.
The only question that I have is how long is the recess so I can inform my client it's going to take longer?
That I don't have in front of me. It is, I think it's 4 to 6 weeks, but I will try and get this up as quickly as possible so that it's right on their desk. I don't believe we can get it in before then, but I'll make sure that it's sitting and ready to go as soon as they get back.
Very good. Thank you.
Yep.
All right. Good day, gentlemen.
Thank you, Judge.
This is case number 22-179518. This is LBNB Funding LLC versus Brian Aaron. The matter is before this court set on for motion for summary disposition. I believe it was adjourned from a previous date. Counsel for the plaintiff, your appearance at this time, please.
Yes, good morning, Your Honor. Michael Kirshenheider for the plaintiff, P75722. How are you today?
I'm good. Good morning to you, sir. And I'm looking for Brian Aaron on the Zoom. If you're on the Zoom, please say something at this time. Brian Aaron, regarding a person living on Monarch Street in the city of Detroit. If you're represented by counsel, if you're anywhere in this Zoom, please say something at this time. The record should reflect that I did set this matter over until today's date at 9:30 a.m. and it is now 10:01. The court, and looking at the file, indicates that the notice went out to Mr. Brian Aaron at an address on Monarch Street in the city of Detroit, indicating that this matter was set over for summary disposition on today's date. Council, have you had any communications with Mr. Aaron that may have any relevance to his being here or not being here, sir?
We have not, my office has not spoken to him since the last hearing, Your Honor.
All right, very well. It appears now then that the defendant has not appeared, and at this time, the court will go ahead and grant the motion for summary disposition in this matter and grant judgment in favor of the plaintiff as prayed in the complaint. So ordered, and the court will enter the order upon submission. You may submit the order by way of email if you wish to do so.
Your Honor, I'm sorry, I didn't mean to cut you off. I believe there's an order in the file. It should be the last page of our motion for summary disposition.
Well, 1 second, let me take a look and see if we've got that. All right, I do see the order granting summary disposition. It does comport with what the court has ordered on this record. I will sign the order and it will be sent out in due course. Thank you, Counsel, for your day, sir.
Thank you. Have a wonderful day.
The court now calls case number 22-242427. This was Edwards Jones versus Transmatic Performance. The matter is before the court on an appeal from the hearing of a magistrate in regard to this matter. Do I have Edward Jones on the Zoom?
Yes, Your Honor.
All right, thank you. Do I have someone from Transmatic Performance?
Yes, you do.
All right. So it looks like you had a hearing on this matter. It looks like the claim of appeal is brought by Mr. Jones. Is that correct, sir?
Yes, sir, that's correct.
All right. So I'll be back to you guys in just a moment. Just hang tight. I'll come back to you. All right. This is case number 22-178599. This is Michigan Diagnostic Center versus Smart. The matter is before the court, set on for a hearing. The court received the answer to the complaint in this matter in April of this year. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Joe DeCruz on behalf of the plaintiff.
All right, your P number on the record, if you will.
P84445, Your Honor.
All right, thank you, counsel. Good morning to you. For defendant Smart, your appearance at this time, please.
Good morning, Your Honor. Andrea Malinowski, P82842 on behalf of defendant Smart.
All right, thank you, Ms. Malinowski, and good morning to you as well. I'm looking to see it. Well, it doesn't look like I gave you a scheduling order on this matter yet. So somebody, well, I see that there was a motion for change of venue. What's going on? Somebody update me.
Correct, Judge. We did file a motion for change of venue. It's defendant's position that venue is not proper in 36th District Court. This matter should have actually been filed in 39th District Court in Roseville based on where the accident occurred. I don't know if, I don't believe we received a response to that motion. I don't know if we want to set a hearing date for that or how the court wants to handle it.
All right, Mr. Bureau.
Good morning, Your Honor. I'm looking through my documents. I didn't see the motion being filed, and I don't have a scheduling order from the court on responses and whatnot. I'm sorry, Your Honor. I do see where the motion was filed. I don't see where the scheduling order and the responses were to be filed. I apologize. So we do have it. It's just that I don't see where the scheduling order is, and it's our position, Your Honor, that venue is proper as Smart has substantial indices inside of the city and does work inside of the city, has picks up, drops off people in the city, and the co-defendant can only be co-defendant at the time could have only been sued in the city of Detroit, being that it was the city of Detroit. So we were forced to sue inside of 36 District Court, and venue would have been proper at the time. For judicial efficiency, it wouldn't be proper to move it now just because that co-defendant is no longer in the case, especially since we've already put time and effort into this. So not sure how you want to do this, if you want us to formally respond, Your Honor.
Yeah, listen, here's where my concern is. Obviously, SMART does have a substantial contacts in a number of different places, but it seems that the location where the claim may have arose would be more appropriate venue. And at least it is being argued, it seems to me, that the accident the incident occurred in a city other than the city of Detroit. And if that's the case, it would seem that venue somewhere other than the city of Detroit. Moreover, the statements relative to progress made with regard to the file, I don't see how any of that would be stymied by the transfer of venue if venue was improperly laid. I don't know if I can finally determine that today, but I guess the critical issue is whether or not the incident occurred somewhere other than in the city of Detroit, and if there is a competent court of jurisdiction that could hear the matter there in that city. In other words, it's not a city where there's a municipal court, but there is an actual district court. So I guess the question is, where did the accident occur? And if the two of you need to kind of talk about that in a breakout room, because of, where the accident occurred cannot be a rolling event unless somebody is making an argument that it was on a boundary line.
Your Honor, I don't think there's any dispute on where the accident actually occurred. I believe it was, as Sister Counsel stated on the record.
So given that the accident occurred in the city of Roseville, what was that? All right. It would seem to me that the venue would be properly laid than in the city of Roseville. Anything further on that issue?
No, Your Honor.
No, Judge, I apologize. The only thing I would request is that in the transferring to Roseville, that plaintiff be responsible for any fees since the venue wasn't properly laid.
Well, that would, excuse me, Your Honor, that wouldn't be necessarily true. The city of Detroit was in this case. City of Detroit cannot be sued outside of outside of the city. So it wasn't improper. This is her motion to transfer. If they want to transfer and pay the fees, be my guest, but we shouldn't be responsible for the transfer if it's their motion to transfer.
Their claim is that they brought this matter in the city of Detroit because they believed, reasonably believed, that the city had some relationship to this matter, and that the city could not have been sued in the city of Roseville. Madam Counsel.
Your Honor, it would be our position that the city of Detroit shouldn't have been sued in the first place because they weren't involved it wasn't on a city of Detroit bus. It was on a SMART bus that the incident actually occurred. So, it is our position that, venue was improperly laid as to defendant SMART, so we shouldn't be responsible for paying any transfer fees.
All right. Well, ultimately, the plaintiff was mistaken in their posturing, legal posturing as it relates to whether or not the city of Detroit should be a part of this claim. Therefore, that mistake is not a mistake that the defendant should be required to be responsible for. That's a mistake that was made by the plaintiff in this matter. The court will grant the petition to transfer venue in this matter, and the cost of transfer will be borne by the plaintiff in this matter. So I'm
right.
not awarded fees. I've simply awarded cost of transfer and spent. So somebody
Okay,
submit an order to me and I'll sign the order report.
thank you, Your Honor.
Thanks,
All right, good day.
Judge. Thank you.
Did you have an order attached on Ms. Malinowski?
Let me double check.
I'm looking as well.
I don't believe we did, Your Honor. No, it doesn't look like it. We'll submit an order to the court. Is there, I believe earlier you may have said that we could submit it via email with another,
Absolutely. That's how I prefer. So if you would send it to the following email address, that's Latifa, Latifah dot Hunter, Hunter, at 36districtcourt.org. 36, that's 36th, 36districtcourt.org.
okay, we will get that order submitted, Judge.
Thank you, counsel. Thank you, sir. Good day to both of you.
Thank you, Your Honor.
Thank you.
All right, this is case number 21-145595. This is AZ Electrical Engineering versus James Jenkins et al. The matter is before the court. I believe I set this on for a review on today's date. Your appearance for AZ, please.
Good morning, Your Honor. Dale Hannah on behalf of AZ Electrical, P81533.
Thank you, Mr. Hanna. Good morning to you, sir. For defendants in this matter, please.
Andrew Patterson, P18690.
All right, thank you, Mr. Patterson. Good morning to you. Good to see you back. Regarding this matter, somebody update me on the, it's a 2021 case, but it seems like it's been here since 2018. But update me, let me know the status of things at this time.
Sure. We've exchanged a couple attempts and did some reviews. The plaintiff worked on two different jobs that are still, I guess, open for the defendant, Jenkins Construction. And with respect to the one job, the plaintiff or the defendant, Jenkins, has reviewed their files, and it appears that there is about $5,000 plus or minus owed to the plaintiff on that job. The second job, however, for the 8th Precinct Annex, we provided, the defendant, Jenkins, has provided all of their information on it, and it indicates that there was an overpayment on that job, and I don't remember the amount. But I was asking the plaintiff for any more records that they might have that would disclose a different accounting so that we could figure this out. But I've not received any, so I don't know. Brother counsel may have an insight on what information they might have on the annex job.
From your perspective, regarding the overpayment on the annex, would that be offsetting? How much would that completely offset the balance owed on the job number one?
I believe it would, Your Honor. I think it was more than 5,000.
All right. Thank you, Mr. Patterson. Mr. Hanna, you may at this time, sir.
Yeah, so I just, I think I've been given a number by my client that would be dispositive on this matter, and I don't think we're far. If I can have an opportunity with counsel and maybe a breakout room for a few minutes, we may be able to just wrap this up and get it totally off the court's docket until we sue them the next time.
All right, that's one thing for sure is in the in the construction business, I practiced before I got here. If you don't get sued often, that means you're not working. So
you're not a real construction company until you've been sued.
All right, so I'm sending you the notice, and then you guys can come back in when you're ready to talk.
Thank you, Judge.
Thank you.
All right. The court is calling case number 21-168814. This is Garden View Homes 1 LDHA LLC versus Chanel Grant. The matter is before the court where an answer has been filed, and looks like the matter has been joined. All right, your appearance for Garden View Homes, please.
Yes, good morning, Your Honor. Dylan White, P80755 for Garden View Homes.
All right, thank you, Mr. White. Good morning to you, sir. I'm looking for Chanel Grant at this time. If you're here to say something, please.
I'm here.
All right, what's your name, ma'am?
Chanel Grant.
All right, thank you, Ms. Grant. All right, so I have received the answer to the complaint in this matter, as I previously indicated. I don't see where I previously set forth any scheduling order, but it looks like there is a motion for summary disposition that has been filed before the court by the plaintiff in this matter, seeking judgment without trial, seeking judgment on the pleadings. Ms. Grant, did you receive a copy of the plaintiff's motion for summary disposition regarding this matter, ma'am?
Yes, I sent in the answer.
All right, and that's what I'm looking for now. Let me take another look to see if there is an answer. All right, so how long ago that you submit your answer, man?
Unfortunately, I didn't submit till yesterday via fax to them, and I hand delivered to the courts.
Okay. Yeah. Now, I see something that is timestamped for July the 5th. It does not say anything about being an answer. It starts out by with a document that says, I see you already have an account created by property manager at Garden View. And then there are a number of pictures.
That was, so I don't actually know what this answer is. I know I had interrogatories and answers. It was in my exhibit. And I answered those questions, and I sent in the support information to show for those answers.
Okay, I do have that. What I'm referring to is the plaintiff filed a motion for summary disposition. That motion was filed with the court in June. And I was looking to see whether or not you had filed an answer to or any type of response to that particular motion. That's what I was getting.
I don't know of that motion.
I'm sorry, say it again.
I don't know of anything of that. I looked through, the last paperwork I received was June 15th from Mr. White's law office. And the paperwork I looked through, I seen the questions and with the interrogatories and the other questions. And that was all I seen. I didn't see any other motion.
All right, got you. All right, so counsel, tell me a little bit about the motion and so that Ms. Grant knows what it's about. And then I'll consider what I need to do next, so if you will.
Yes, thank you, Your Honor. This is plaintiff's motion for summary disposition based on a C9 and a C10. Plaintiff entered into a lease with defendant to rent housing property at 8280 Grandmont Avenue in Detroit back in 2010. The property was provided under the terms and conditions of the lease. Defendant was to pay the balance, but defaulted by failing to pay as promised, and a consent termination judgment was entered. That's attached as Exhibit 2, Your Honor. Defendant failed to provide a forwarding address within 4 days of vacating the property at that time. She left an amount due and owing of back rents.
You broke
What was
up
that,
a
Your
little
Honor?
bit.
Sorry.
The last thing I heard is that she left an amount doing owing as back rent. You may continue.
Yes. she left an amount due and owing of back rents and other fees of $2,129. We brought this claim. Her answer agrees that a lease existed between the parties, and that her consent termination agreement absolves her from paying any back rents due and owing under the terms of the lease. But when you look at the termination agreement or the termination judgment, the check number 6 is checked saying that she may still be liable for other back rents in the future. Her security, she also stated in her answer that her security deposit of $753 absolves her from the debt due and owing of the plaintiff, but that security deposit has been accounted for in these damages calculations, Your Honor. She raises no other defenses other than defendant's contributory negligence, but she doesn't really say what defendant's contributory negligence was. In addition, on May 10th, 2022, plaintiff issued discovery requests. And as of the time that we wrote this motion, Your Honor, on the 15th of June, no responses had been received. So we would say that plaintiff or defendant has admitted in her discovery request to the due and owing amount of $2,129. In addition, Your Honor, plaintiff has not filed a response under 2.116.
You knew word. These always seem to be on Zoom these days. So,
Yeah, Mr. Patterson, you were on, I was hearing you side.
He's cutting in on us.
Sorry, Mr. White, you may continue, sir.
That's fine. Summary disposition would also be proper in this case because the defendant has failed to file a response under 2.116G4, which requires that she cannot rest on allegations in the pleadings, but must file a response with an affidavit. We would ask that Your Honor grant plaintiff's motion for summary disposition in this case.
All right. Thank you, counsel. All right, Ms. Grant, you understand the nature of the motion that has been brought, asking that the court grant judgment by summary disposition at this time. You understand what counsel is arguing in this regard?
I understand, yes. Although I didn't know about a 28, and I know ignorance of the law does not help me. I didn't know about a 28-day rule. I only got what I got from you in the courts. When I was last talked to you, I had to have everything in by the 7th. I didn't know it was a 28-day rule.
All right. That would have been included in the motion documents, or I should say the documents that were submitted to you, the request to admit and what have you. In that document, it tells you the time frame in which you have to answer those items. But let's look beyond that for a moment. The critical thing here is that what the plaintiff is arguing here is that when you left from the premises that there was some rent that was due and owing, they argue further that that there was in fact a security deposit. That security deposit has been accounted for in the sense that it paid for some other obligations that were due, and that the amount left after all of those issues is the $2,100 that they claim to be due and owing. Do you have any amount in mind that you believe that you owe with respect to this property after having moved out, ma'am?
Yes. I occupied the home without paying from March, April, and May. I was out by May 31st. I do owe for March, April, and May. My rent was $440. When I look through their ledger, I see, and I have an email where I spoke upon some extra fees being left on my my portal where I couldn't pay it because it only allowed that amount. So nothing ever changed. So I do see that on there. I see where I pay $440. And then I see when I get to, May, they charged me the whole rent. I had Section 8. I was only charged the rent, the portion that I am owed through Section 8, which would be that $440. Then they charged me for June. I didn't live in the home in June. No, I didn't give them a forwarded address. I was homeless for 30 days.
All right. So when did you notify them that you were moving, or did you tell them that you were moving, or?
You have to notify with Section 8 in order for me to keep my Section 8. I had to
Slow down.
notify them with the intent to move.
Slow down. Let me,
Sorry.
your cadence is a little bit fast, and you started talking even faster there, okay? So start at the beginning, because I couldn't keep up with your words, so go ahead, man.
In order for me to stay on Section 8, I have to put in an intent to move. It had to be a 30 or 60-day intent to move. So yes, I did put that in with them.
Okay, and were you in fact under a lease agreement?
My lease agreement became month to month after the year signed, and I moved in 2010. I was there for 8 years.
Okay, all right. So I guess the answer to my question is that yes, you were under a lease agreement, but the lease had expired at some point, correct?
Yes.
All right, very well. So of course, you know, if you calculate the 3 months, it comes to $1,320. And then I'm sure they would charge some late fees, and then some other fees would apply in regard to this matter. Mr. White, how is it that the plaintiff gets to $2,100 in this matter?
So it looks like they're going for unpaid rent from March, April, May, to looks like June as well. Billing. Late fees for those months, and a legal fee, which I am assuming is coming from the termination action that had to be filed.
So how is it, the defendant indicates that she moved out of the property by the end of March, and
Or was it March or was it May?
May.
I'm sorry, thank you, by the end of May, and that would have left 3 months. Obviously, when you leave out, the plaintiff has the right to charge, to continue to charge until they've been able to put someone else in the premises, or et cetera, et cetera. That's generally the way that works. All right. So, but how do you, I mean, this, you got two, so arguably you got 2 more months. 2 more months in this, and that's what's bringing it to the amounts that you're looking. All right. So here's my thought on this, and I want you all to go in a breakout room to see if you can talk about this. I think that it looks like to me that 3, maybe 4 months, you're going to have a difficult time moving away from the obligation in that period. And additionally, there's the $140 in fees. You have a difficult time getting around that. As it relates to the legal fees, where there was a consent resolution, I would require that fee be cut in half, and so that would bring you to basically a fee of $162.50. So your fees that you're going to run into in this case would be the legal fees that the court would posture that they should be cut in half, would be $162.50, and then a $150 in other charges. That would be that brings the amount to $302. So $302.50, and if you got the 3 months at $13.20, that brings it to $1622.50. Now, $1622.50, and an argument about 1 additional month, where the law would typically allow a 30-day period after exit. Sometimes it would allow for a 60-day period after exit. Here's what I want you to do. I think this case is somewhere between $1622 and $2,000. Why don't you talk in the breakout room and see if you can resolve it? I like the $1650 number, but if that can't be resolved, then it can't. At least see if we can do that, and then I'll allow you to come back in and talk to me. And if you're not able to resolve that, then I'll make a decision on what to do next. Because the motion, I would want Ms. Grant to have a chance to read over it. She says she hasn't received it yet. But you're not that far apart. This is not a pleasant thing because obviously it's a move out and so on and so forth, but it may be a way to resolve it short of having to come back and forth and so on and so forth. So I'm going to put you in a breakout room to see if we can talk about it a bit. And no pressure, come back in and the court will take it from there. All right. So click on in, Ms. Grant, the two of you get a chance to talk, Mr. White, and see if you can get it resolved. And I've already given you some direction as to where the court's thinking may be. All right, so look on your device, Ms. Grant. You'll see that I've sent you a notification for a breakout. All right, and I'll be here to return.
And just so you know, Your Honor, I am also here on the Deandra Fields case as well.
All right, and let me hold on 1 second, sir.
So if that was going to be the next case you call, just give us a few minutes while we take care of this, I guess.
Yeah, that's what I was getting. I want to make sure I got my hands on it. Yep, and I'll hold off until you're back on that one.
Okay.
Ms. Fields, I see you there. We'll be getting on that matter in just a moment. All right, Mr. Hammond, Mr. Patterson, we are back on the record regarding the subjects 5595. That's AZ Electric versus Jenkins et al. All right, you may at this time.
Judge, I think we're very close, and I believe that we should be at resolution, and we're just asking for like a 14-day hold date, just so that we have that, and depending on Mr. Patterson's ability to convince his client, we could resolve this matter.
All right, Mr. Patterson, it makes sense to you that I take another look at this in 14 days?
It does, Your Honor, it does. I'm hopeful that we can make some progress.
All right, very well. So I'll go ahead and set it over just a couple of weeks.
27, what, 27?
Yeah, July 27th. And I'm going to set that at 10 o'clock a.m., gentlemen, July 27th, 10 o'clock a.m.
Yep.
All right, we'll see you at that time. All right, all the
Thank you.
best.
Thank you, Your Honor.
Thank you, Judge. Is that at 9 o'clock, you said?
10.
o'clock a.m.
10 p.m. Thank you.
All right, Mr. White, Ms. Grant, you're back quickly. Let me know what's going on here.
They only wanted to go for the whole amount with a payment agreement.
All right. Counsel, is that about the position in this matter? I think it's something that needs some degree of compromise under all of the circumstances. And that's why I gave the suggestion that I'm given this matter.
Yeah, yes, Your Honor. At this point, that's all that plaintiff is willing to discuss with defendant.
All right. Well, now you're not just discussing with the defendant. That's the position you take before the court is that you're not willing to compromise on this scenario, sir.
Unfortunately, no, Your Honor.
All right, very well. So what I'm going to do is I'll reset the summary disposition motion, and counsel, I need for that to be sent out to Ms. Grant. Ms. Grant, I'm going to give you 30 days to provide some type of written response as it relates to this matter, and then I'll take a look at it and we'll conduct a hearing on it. So, counsel, I know that I have a proof of service attached to your filings, but although Ms. Grant has indicated that she receives several other documents, she says this one she didn't receive. She did, in fact, respond or file with the court various answers to interrogatories. I've received those, and I don't know if you received a copy as of yet. But Ms. Grant, if he is not, you need to get a copy of the answer to interrogatories and request to admit that you filed with the court. You need to send that to Mr. White's office right away.
Your Honor, as far as the interrogatories and requests to admit goes, MCR 2.302 G2 requires a signature on those interrogatories, and we just don't have a signature. So we would ask that those be stricken because they are roughly a month late as well.
All right, and the court has heard you, the court has heard you on the motion. I will, I'll deny the motion to strike the answers. Ma'am, you will have to in fact sign off on those documents and make sure that you sign them and then resubmit them if you will, or provide a signature page. And counsel, resend the motion to the defendant, and then, ma'am, you'll have 30 days to answer the motion. And then the next hearing date is going to be.
You said, we got 32, August 15th. August 15th.
Yeah.
Later on is that, okay, August 15th, so we're talking about August the next week, that other week, right? So you want to do August 18th, or you want to, you have to go all the way after that. Again, September.
All right, we'll go ahead and set it for August the 18th, August 18th, and that's going to be at 9:30 a.m.
9:30.
8/18, 9:30 a.m. That's when you're coming back in front of me. Let's get the documents out that I've indicated, so that response can be filed to the motion.
And
Your
we'll
Honor,
resend that motion, Your Honor.
Excuse me, I'm sorry. Can I get a change for a mailing address so I can make sure I'm getting the documents?
Why don't you, so your address is on Coyle Street, is that correct?
Yes, I'm preparing to move from this address. I just want to make sure I get whatever it is I need without any problems.
So do you have the address where you're going to?
No, but I have a mailing address. It's my parents' home.
Okay, so why don't you, you know how to put that in the chat?
Yes, I do.
All right, why don't you chat that to myself and Mr. White? And we'll make sure that the file is documented for the change of address. All right, and so the next day is going to be the 18th at 9:30 a.m. So you go ahead and chat that information, Ms. Grant. We'll put that in the file, and Mr. White will get it as well.
Yeah.
Say.
All right, we're back on the record regarding file number 21171768. That's Auto Club Group versus Deandra Fields, Cedric Fields, and Deanna Lucas. The matter was before the court regarding whether or not there was a responsive pleading to the complaint in this matter. I have received from the file room various answers that have been submitted regarding these matters, and your appearance for the plaintiff counsel.
Once again, Your Honor, Dylan White, P80755 for Auto Club Group.
All right, thank you, Mr. White. Mr. White, have you received the various answers that were filed regarding these matters?
Yes, we just received them, Your Honor.
All right. And who do I have on the record here? Say your name, please.
Deandra Fields.
Thank you, Ms. Fields. Who else do I have?
Good morning, Your Honor. Dina Lucas.
All right, thank you, Ms. Lucas. All right, and
Cedric Fields, Your Honor.
all right, thank you, Mr. Fields. Good morning to each of you. All right, so I have received the answers. They were delayed in being submitted. I know that there was a petition for entry of default judgment. I will allow the answers that have been submitted in this matter at this time. This is a case that seems to be about some $3,813 in this matter. So I guess one of the ways to do this is to talk about whether or not there is some opportunity to settle this. That would involve some payment being involved, but it would involve the parties coming together and talking about ways of trying to resolve this, perhaps for something less than what is being claimed. Any interest in doing that? Ms. Fields, Mr. Fields, Ms. Lucas?
Well, Your Honor, we do have,
Yes, sir. Question?
oh, I'm sorry, yeah. I don't know how to go about this. But we do have pictures. And I don't know if we can get together and show pictures. But
Your Honor, no, I feel like I should not have to pay nothing. Sorry.
Well, like you should what?
I said I don't feel like I should have to pay for her damages. Because I paid out of pocket for my own.
All right, gotcha. All right, so what I'm gonna do is I will set a scheduling order on this file. And I'm going to allow a period of 60 days for discovery in this matter. Now, discovery is the process of exchanging information that is consequential. Either party can submit to the other party a request for documents, a request for any information that they believe pertains to this case. Either party can submit documents called a request to admit, where it asks one party or the other to admit that certain things are true or false. The party can submit a document that's called a set of interrogatories. Interrogatories are a set of questions that ask questions about a number of specific events. And either party that receives that is required to provide answers, and required to provide those answers within 28 days of having received the documents. So the 60-day period is going to allow for either party to request documents, copies of files, copies of any information that may be available, etc. After the expiration of that period of time, I'm going to set a pretrial hearing date. The discovery process allows both sides to discover and understand what the claims of the respective parties are all about. And it oftentimes results in resolution of the case, sometimes by way of what's called a motion. The motion can be one that disposes of the case, or one that just addresses something in the case. A dispositive motion is one where someone files a motion saying that the case should be dismissed, or the case should be resolved in their favor in some kind of way. So those kind of issues will come up in the next 60-day window that I'm going to provide. This process that you're embarking upon is called civil litigation. It is civil litigation. I know that if you don't have an attorney involved, that you may not know all the things about that, but you're still held to the same responsibility as if you have an attorney involved. And if you choose to get an attorney involved, you certainly can elect to do that if you believe that that's what you want to do. But if you don't have an attorney, you still have to respond to documents. You still have a right to ask for documents. You still have a right to raise questions in writing. Any of those things that you want to do, you're not prevented from doing that by not having a lawyer. You can do that on your own. All right. So the next action date in this matter is going to be September the 12th. That's 9/12/22. I'm sorry, and that's going to be at 9:30 a.m. You're going to receive from me in the mail an order. That order is going to be an order allowing discovery. It's going to be a pretrial order. And in that document, it will tell you that you have through September the 12th to to engage in discovery. You'll have up until and through that day to engage in discovery. We'll also provide that either party can file a motion if they wish to, asking that the case be resolved by the court. As long as they file that motion and allow the other party to have at least 10 days to respond. So the 12th of September will be or can be a hearing date on a motion. If you file a motion and you allow the other side at least 10 days to respond, I will hear that motion on the 12th of September. Now, all of this information will be in the written order that you're going to get from me. You'll get it in writing that talks about the things that I've talked about. It's going to be a written document signed by me. I'm going to mail it out today to the respective parties. If someone sends you a request for any documents or request to answer questions, you have to make sure you answer them within the time that's permitted by law. And then we'll have a hearing on the 12th of September 2022 at 9:30 a.m.
Your Honor.
Yes.
So that date's kind of cutting it close. I'm pregnant. My due date is September 14th.
Okay.
So I don't know when she's coming.
All right, well, we'll see where you are at that time. I'm sure that one of the other parties in the case will inform me as to your situation at that time, and we'll certainly consider that. Yeah.
Okay, thank you, Your Honor.
That won't be held against you, that's for sure. All right.
Okay, because I'm like, I don't want to be in the hospital on Zoom.
Yeah, and if you're in hospital and if you're in the process of having a baby and so on and so forth, like, you know, we all understand how that works, all right? In the meantime, do everything that you can in relationship to this case. And of course, when you're on a disability, we don't expect that you'd be able to respond. But given that there are three parties, three defendants in this case, somebody will be on this record and they'll let me know what's going on at that time.
Okay.
Right? So September 12th, 2022, 9:30 a.m. You'll get a written order from me in this regard. All right. I wish all sides well and good day to you. Like I said, you'll get the order in the mail in the next few days.
All right, thank you.
Okay, thank you.
Have a good one, Your Honor.
Thank you, Your Honor.
Okay, we have 60 days. So what we'll do is we'll get worked down.
Hold on, can I leave? I'm trying to do-
All right, we're back on the record regarding the suffix 2427. That matter is an appeal from the finding of a magistrate regarding this matter. It is the case of Edward Jones versus, Transmatic Performance. All right. And Mr. Jones, you've indicated to me that you are on this Zoom. Who's here for Transmatic Performance, please?
Yes, sir, that's correct.
What's your name, sir? I have Mr. Jones. I have Edward Jones. Who's here with Transmatic Performance, please?
Clayton Quates.
I can hardly hear you, so wherever you are, you got to get to your device or something, because you sound like you're about 6 miles away. Talk to me.
Clayton Quates.
Clayton.
Wait.
What's the last name?
I can't hear him, Judge.
Yeah, the court report's gonna, what kind of device are you on? Where are you? Because if I can't hear you, we're not gonna be able to do this.
Okay, Clayton Quates. Can you hear me?
Okay, I hear you now. What's that last name? Spell that last name
Turn
for
it
me.
up. Quates. Quates.
All right. Thank you, sir. Madam Reporter, what did you say, ma'am?
Oh, no, I just said, I think he's in a car. I don't know.
No, I'm at my house.
Okay.
I'm at my house.
Yeah,
I heard here.
you kind of, the problem is that you kind of go out and go in. I heard you real clearly then, but then there's like something going on in the background.
Right.
It's important.
Let me move away from this. Can you hear me better now?
Oh, yeah, that's much better. That's much better. All right, give me that last name one more time.
Quates. Quates.
Quaques?
Yes. Quates.
TES. yes. Oh, gotcha. That's how hard it's been for me to hear. Okay, we got you now. All right, are you able to show your video for a moment, sir? Are you able to come on video?
Am I able to show a video?
Yeah, are you able to see? I'm not able to see you. I'm hearing your audio on the audio, but I need to see your face for a moment.
Oh. I'm not real fluent with this.
Yeah, if you could click on video, it'll show you, just so that I can swear you in as witness.
Click on video.
Yeah, you're on audio, and if you click on video, then it'll show you for a moment.
Okay, hold on one second. Oh, he wants me to click on video. Hold on one second.
All right, sir.
It should be the bottom left if he's on a computer.
On video. Okay, trying to see how you click on video.
Judge, I think it should be on the bottom left corner if he's on a computer or.
No, I'm on.
Oh, no, he's on a phone.
I'm on a regular phone.
Well, I'm not sure what you need to do. All right, let me do it this way then. Let me have both of you, Mr. Waits and Mr. Jones, let me have both of you raise your right hand to be sworn at this time, please. Raise your right hand to be sworn. You do solemnly swear or affirm that the testimony you are about to give is the truth, nothing but the truth, so help you God.
I do.
Yeah.
All right, very well. Given that this is Mr. Jones' matter that is brought before the court, Mr. Jones has the burden of proof, and therefore he gets to go forward first to tell me what he wishes to tell me regarding this matter. And after he has presented what he wishes to present to the court, then I will give Mr. Quates an opportunity to tell me what he wishes to tell me. So, Mr. Quate, if you'll mute yourself for just a moment, I'm going to hear from Mr. Jones, and after I've heard from him, I'll come to you, sir.
All right.
All right, thank you, sir. Just mute yourself for just a moment so we don't have any sound in the system. All right, and again, good morning to you, Mr. Jones. You've been sworn as a witness regarding this particular matter. Tell me what this case is about, sir.
Good morning to you, Your Honor. Well, I did go to court with Judge Rodney Johnson.
Yeah, that's the magistrate. Yeah. And when you go in front of a magistrate, you always have the right to appeal to a higher authority, which is an actual judge. And I am a judge, and so I'm going to hear this from the beginning to hear what this case is about. So yes. Go ahead and tell me what the case is about.
Okay, this case, my vehicle had
let me stop you for a moment. I don't know if you moved your device around or something because it broke up a little bit. And so you kind of some static came in. So I want to be.
Can you hear me now, Your Honor?
Yeah, I hear you fine. All right, so you have a vehicle. What type of vehicle do you have that's involved in this particular matter?
It's Arcadia, on a 2009 Arcadia.
2009 Arcadia?
Yes,
right.
Sir.
And at some point, you took that vehicle to Transmatic Performance to have some service done on it. Is that correct, sir?
Yes, that's correct.
All right. Did you speak with Mr. Quates when you took the vehicle there?
Excuse me?
Did you speak to Mr. Clayton Quates?
Yes, sir, I did.
All right. And so what did you, how long ago was this? When did you go to have the vehicle assessed or repaired? How long ago?
On his January 16th, 2020. I have a procedure that I didn't own that vehicle in January of 2020. I didn't own the vehicle 5/12/2020. I also have my, and you should also have the, in front of you, my insurance said that I didn't drive the car until June.
It's just messed up.
You're breaking up badly, and I have no idea why.
I'm gonna put my phone up to my mouth so I can, the speaker, and I hope that you can hear me a little better. Can you?
Yeah, I hear you fine. It's just, I guess when you start talking, it seems that you're moving or something, and then the system starts giving me static. So.
Yes, I have information here in front of me, and I was.
It's doing it now.
Yeah, it's breaking up. It's breaking up now. All right.
Am I still breaking up, Your Honor?
Yeah, you're still breaking up. All right. So let me try to recount some things and see if we can get there. Here's what I'm understanding you to tell me that that you took the vehicle in for repair. You spoke with Mr. Quates, and then you started talking about a date of a receipt date of January 16th of 2020, and you said you didn't own the vehicle at that time, and it wasn't sometime until May of 2020 that you actually owned the vehicle. Is that what you told me so far?
That's correct. Yes, sir.
All right. So why did you have a receipt for January when you didn't own the vehicle until May?
That's the receipt that he wrote saying that he did the work on my vehicle.
All right. Now, the receipt that was written indicating that there was work that was done. Did you pay that receipt? So you paid in money based upon that work that was done on that receipt?
Yes, sir.
All right. How much money did you pay?
I paid $2,500.
So why did you pay him for a repair that is claimed it was done in January of 2020 when you said you didn't own the vehicle at that time?
Well, at that particular time, I wasn't paying any attention to the date on the receipt. I was just he told me to bring him a down payment of $1,000, and I did. And it took him 4 months to do the work on the vehicle, and I took him $100. And I was just glad to get my vehicle back at the time. And I wasn't paying no attention to the date on the receipt. I just gave him the money, and he didn't write me a receipt for when he gave me my car back. And I gave him he didn't write me another receipt.
It's breaking up, Joe.
Yeah, you're breaking up badly. Let me ask you, when did you actually take the vehicle in? What month and what year did you actually take the vehicle in for repair?
I took the vehicle of 2021.
When in
2021? By being so close to 2020.
Let me stop.
Hang up and call back.
Do you have another device that you can use, sir?
Oh.
I'm sorry?
No, I don't.
Well, just like you're talking right now, I need, you got too much moving around going on. That may be what's causing the static. You have way too much moving around going on. Because
I don't know why the static is going on. I'm not moving around.
Right there. Yeah, I can see on the video that you're moving around, that the phone or something is moving because you're constantly moving. But right now, like you're talking now, I hear you perfectly clearly.
Okay.
There's no static.
Right here. I'm trying to stay right here and talk to you.
Okay, all right. So let me ask you, you took the vehicle in 2021, is that correct? Don't move forward. Don't do anything.
Yes,
Can
sir.
you hear me okay?
Yes,
Can
sir.
you hear me? Okay. You took the vehicle in 2021. That's what you're saying, correct?
Yes, sir.
Was that January 2021?
Yes, sir.
All right. So the receipt says 2020, but it was actually 2021 when this occurred. That's what you're saying, correct?
Yes, sir.
All right. when did you get the vehicle back? What month did you get it back in 2021?
It was April,
You said April?
April or May. It was 4 months later.
Okay, so sometime April or May, you got the vehicle returned to you, correct?
Yeah,
What's the total amount of money that you paid for the repair on the vehicle?
$2,500.
All right. Now you put 1,000 down when you got the vehicle, when you left the vehicle there in January, and then you paid some more later. Is that how it happened?
Can't hear you.
When I got my vehicle back,
Okay. Let's do that again. You paid how much when you took the vehicle in?
I gave him $1,000 in January, and then I gave him $1,500 more when I got my vehicle back.
All right, very well. Got you, sir. Okay. What did you pay him to do on your vehicle?
He was supposed to rebuild the engine.
And when you took the vehicle in for the engine rebuild, what problems or issues were you having with the engine at the time that you took it in January 2021?
Well, I had took it to Myers.
Okay, you breaking up now.
And when I tried,
Yeah, I can't hear that. Does he have on headphones?
Let me see if I can construct what you said. You said that you took the vehicle in before going to Transmatic. You took it into Myers somewhere.
no, Your Honor. You asked me why was the reason that I took it to them was because the car just stopped on me.
Okay, all right. So when you when you went to have the defendant take a look at the vehicle, did they tell you, is that what they told you, that it needed an engine rebuild?
What he told me was that because I told him that I probably needed another engine, and he has told me that let him take a look at it. And he took a look at it, and he called me back in a couple of days. He said, yes, you need another engine. He said, but I can rebuild this engine. He said the engines for this particular car, it costs a lot of money and they're hard to find. He said, but I can rebuild this engine and I can have you running like it's brand new. And I asked him, well, how much would he charge to do that? And he said $2,500. So I told him to do it.
All right.
So at that particular time, he told me $1,000.
Okay, you're breaking up now.
Yeah.
Let me
Bring
stop
him
you.
about.
Okay, let me stop you. You're breaking up, but it sounds like you said that at that particular time, you gave him $1,000 and then you returned, you gave him the $1,500 after you picked the vehicle up, correct?
Yes.
Okay. All right, sir. So what problems did you encounter when you picked your vehicle up? How did you know that there was something wrong? Well, tell me what happened after you picked the vehicle up, sir.
I started losing pressure. I started losing pressure.
Let me stop you. I need you to reposition yourself again because you're breaking up again. Some kind of way when you said you're real clear, and then some movement, and then it starts being static. So reposition yourself and hold your phone, and then tell me what happened after you got your vehicle back. You said, I heard you say that you started losing pressure, but I didn't hear anything after that. So go ahead.
Oh, well, when I got my vehicle back, I drove my car. And I just got off of work and I went to the grocery store. And as I was leaving the grocery store, I heard a lot of noise going on. And when I got across the intersection of the light, the car just stopped. And I tried to turn it back on, and it wouldn't turn back on. So that at that particular time, I had my car towed to another shop. And they told me that the engine was gone.
Now, how long after you picked the vehicle up that you have the problems that you described? Okay.
From the first time, I drove my car for about 4 months.
The first time, 4 months. Let me see.
Yes, I drove my car about 4 months, and the engine blew again.
Okay, let me stop you. Make sure I'm understanding. So when you picked the car up in April of May of 2021, you drove it for about 4 months after that before it went out?
Yes, sir.
Okay. And then after it went out that time, what, you went to another company, another repair shop?
Yes, sir.
All right, and that other repair shop, they told you that you needed an engine, correct?
They told me that.
Okay, you broke up there. That's what they told you needed an engine?
In here.
Okay, I can't hear that. So say it again, sir. Hold your head up and say it again. Yeah, I can't hear you.
Can he hang up and call back, Judge?
Can I do what?
Yeah, but no, I need you just where you are right now. Look at me. Look on the screen where you can see me. Okay, now tell me what you said, because that's usually where I can hear you, is where you are now. When you're leaning in, that's when it starts breaking up. Okay, so tell me, you said that the other company told you that you needed an engine, correct?
The engine was blown. They said that the engine was gone.
Okay, all right, real good. Now, after you picked the vehicle up in April or May, did you ever take the vehicle back to that shop, to the shop that had repaired it?
Well, he told me that I told him it was leaking oil. And he said to bring it, he said I would have to bring it up there to his shop. And at that time, I was like, I don't want to deal with him because he kept my car too long to fix it. He kept it for 4 months. So I took it to the guy who did the work on it this time.
All right. And did you in fact get the vehicle repaired by another company?
Yes.
How much money did they charge you?
To repair the car?
Yes.
Well, they didn't. Well, what happened is that I had Car Shield.
Okay.
And I asked them, could they fix the motor with Car Shield? He said yes. So they got in contact with Car Shield, and Car Shield was going to pay for it.
All right. And did you
Car Shield denied the claim, and I had to pay $500 out of my pocket.
All right. And was the car in fact repaired? Was the car repaired?
No, the car is not repaired. What happened was the people that, when the Car Shield came there, Car Shield had them break the engine down. Okay. And when they broke the engine down, they found a rag inside the engine. So he called me and he said, man, did somebody work on this car before I got it? I said, yeah, I had my engine rebuilt. He said, well, they left a rag inside the engine. And he said the rag is stopping the oil from lubricating your engine the way it's supposed to. He said, one side of your engine It's getting hot, too hot. And he said, that's why your engine blows.
Okay.
And that's when I went in and I to a small claims court.
All
I
right.
brought this
Gotcha.
to the court.
So the reason that you didn't finish with the repair is because the coverage that you had would not repair it, but you still had to pay $500 to get it to get your car back because they had broken it down, correct?
Right.
Okay. All right. Anything else you want to tell me at this time, Mr. Jones? No, keep
The
it
other
in.
judge in this guy's favor.
I don't need to know what the other judge did. This is like a new hearing. All right.
Okay. I'm sorry.
Yeah, I'm not interested in that. Okay. Did you receive when you picked up your vehicle, did you have a warranty regarding the repair?
He said a warranty was for like 90 days.
And the problem that you had afterwards, or the problem that you had with the vehicle, those problems began to occur after 90 days. Is that correct?
Yes, sir. Well, they were occurring like at the oil leak. It was occurring before 90 days. But I was afraid to take my car back to him because I was working at the time and they kept my car for 4 months. I was afraid to take it back to him and they just keep my car. I wouldn't have had a way to get back and forth to work.
All right, gotcha, sir. All right, anything else you wanted to tell me, Mr. Jones, at this time?
No, sir.
All right, thank you, Mr. Jones. All right, I'm coming to Mr. Quates at this time. Mr. Clayton Quates, you've been sworn regarding this matter. Sir, did you in fact, you and your company perform repair services on a vehicle brought to you by Mr. Jones, sir?
Yes.
And was that in January of 2021, sir?
Yes.
All right. So sometime in April or May, the vehicle, the defendant picked up the vehicle and he paid you a total of $2,500 for a rebuilt engine. Is that correct, sir?
No.
All right. What happened, sir?
What he brought his vehicle in, it wouldn't start. Been over, but wouldn't start. Tried to start, but wouldn't. So it ended up having a timing problem. And that's what frequently goes bad in the 3.6 engines. Is in a lot of them, they use the wrong oil. Timing starts to get slack in it, or one of the guides break or whatnot. That's what happened to his engine.
Okay.
And
I can already hear you, so I need you to be near your device. But you were talking about you diagnosed a timing problem. Is that a timing chain problem?
Yes.
All right. So you diagnosed that the timing chain was going bad, and that would ultimately lead to engine type problems. Correct, sir?
Right.
All right. You may continue to tell me what you ultimately concluded about this vehicle and what you did with this vehicle. Mr. Jones, go ahead and mute your device, Mr. Jones. Go ahead and mute your device so I don't get any background sound. So I can listen to Mr. Okay. All right. Go ahead. Go ahead, Mr. Quates.
And well, the Cadillac converters were plugged up too from the carbon, from the timing being off on the motor.
Okay.
That's why it wouldn't restart. So that's what we repaired. We cleaned the timing, fixed the timing chains and components, and cleaned the Cadillac converters out. Started right up.
All right. Now, on your receipt, you gave the gentleman a receipt for services performed. Is that correct?
Yeah.
All right. Did you document on the receipt what services you performed, sir?
Yeah, and verbally told him.
So it looks like I have a document that shows $2,500. It says deposit of 1,000, balance of 1,500, 90-day warranty. And it says on the part, on one part, it says rebuild engine and timing.
Right.
That's what your document says. Is that correct, sir?
Yes.
All right, so when you say rebuild engine and timing, you told me about the timing. What does it mean here with regard to rebuild engine?
It's just part of tearing it all down and putting it all back together. The whole engine had to be taken out and torn down to do the timing.
Okay, so what in fact did you do? Tell me what you did.
I rebuilt the timing, tore the motor down, checked the motor, see if anything was damaged on it, and figured out why the motor wouldn't start. But this isn't the first motor I've ever done, so I know these things have timing issues. But the motor has to be taken out to even tear the timing down. So it's very close. Yeah.
All right, so let me, and just so I chime in here a little bit, so that when we talk about the timing or the timing chain or timing mechanism, that is, and God knows I'm not a mechanic, but the reason you talk about breaking down the engine is because you're saying that timing chain is somewhere about middle ways in the engine, correct?
It's in the front of the engine.
Yeah, but you have to, I guess what I'm getting at is there's something, you got to take a lot of stuff apart to get to it, right?
Yeah, definitely. That's the whole front of the engine. Valve cover's got to come off. But you can't do it in the car. It's just too tight.
All right.
And if you look at
you have to lift the engine out of there with the proper devices and then put it on some type of hoist or whatever and begin taking it apart to diagnose the
can't
problem.
lift
Is that
it
what
out.
you're saying?
No, you
Go
can't
ahead.
lift it out. You have to drop it from the bottom.
Okay.
It has to sit on the frame. You have to drop the whole frame of the car with the trans in it and the engine, drop everything down.
Okay. All right. And if in the process of dealing with timing chain issues, you discover that there are other things that are problematic with the engine, then the rebuild would continue into other aspects of the engine, correct?
Correct.
And here you diagnosed the timing chain issues. You indicated to me the issues regarding the catalytic converter and that you were able to clean those items out. And then the car, the vehicle, once you reassembled, the vehicle started up and was operating, correct?
Correct. That's a timing chain and its components. It's got guide rails and tensioners and whatnot. All those had to be replaced too.
So I see on the form or the document that I should say the receipt that I received into evidence here. Both parties agree that this is the receipt. I'll come back to Mr. Jones in a moment. On that receipt, you indicated that that there was a 90-day warranty for this repair. Is that correct, sir?
Yes.
Was the vehicle brought back to you during the 90-day warranty period?
Only he brought it back once for an oil leak, oil sending unit, the oil sending unit, which is the oil pressure switch, started leaking on it. So we put a new oil pressure switch on it, and I never seen him again after he left in.
All right. And so the vehicle was not brought back or towed back to you or anything in that 90-day period
No.
for engine repair or anything along those lines, other than what you described regarding this oil situation, correct?
Right. Just an oil leak. Yeah.
All right. Anything further you wish to tell me at this time, Mr. Quates?
No, that's basically it.
All right. Thank you, sir. Mr. Jones, anything further you wish to tell me? I did go over the receipt that was sent to me, and I also I've noticed other documents regarding the subsequent services that you sought after, Mr. Jones, for the repair of your vehicle. I've noted those items. So tell me, anything else you, Mr. Jones, anything else you wanted to bring to my attention regarding this matter, sir? And Mr. Jones, you're on mute, sir, so you want to press *6 to come off of mute if you have anything to say to me, sir. *6 will bring you off of mute, and then you can talk to me, Mr. Jones. All right, Mr. Jones, if you have anything else to say, press *6 on your phone. There you go. Anything else? Okay, now sit back from your phone like you like that. Yeah, that's usually when I can hear you best.
Okay, what I have to say is that, you know, on this.
No, stay back. Stay seated back, like whatever you, when you come forward is when I start getting the distortion. So just sit back like that. Yes, go ahead. That's something is messing up. Reposition yourself because it's some movement that I can't hear you. Other times I can hear you extremely clearly. So let's try again, Mr. Jones. I can't see you. Let me see you, sir. Come back. Yeah. Okay. Let's try there. Go ahead, sir.
Like I was saying before, Your Honor, I don't know if you got it, but it's a rag inside my engine that transmission performance they left inside my car once they did the work. And the way hot, real hot, and because it was, and that's why the leak, because of the rag. And that's why I brought the small claim. I wouldn't have said, I wouldn't have done anything. I'd let this go, but it was a rag inside my engine that caused the engine to go bad.
All right.
And then he put on the receipt.
Yeah. All right, sir. All right. Thank you, sir. All right. All right. Thank you very much. I've heard the evidence offered in this case, and I'm going to now make my decision regarding the outcome of this case. This is a situation where both parties agreed that Mr. Jones brought the vehicle to Transmatic Performance for repair, and that while there is a receipt that indicates that the repair was done in January, or that the vehicle was brought to the property in January of 2020, both parties stipulate that the date on the receipt is not the correct date. That is simply an error that was made in putting the date. That does not have any real impact on this case. The fact of the matter is that Mr. Jones indicates that this was in January 2021, and Mr. Quates indicate that it was in January 2021 as well. The putting of 2020 on the receipt was simply a mistake regarding the date. What the parties further agreed is that the vehicle was picked up sometime in April, May of 2021, and that when the vehicle was picked up, a balance of $1,500 was paid for a total amount of $2,500. On the receipt, it provides a notification that that a warranty is provided on the work that was performed of 90 days. In the interim of that 90-day period, Mr. Jones did bring the vehicle back because there was an oil leak. That oil leak situation was corrected. And then sometime subsequent to the expiration of the 90-day period, the vehicle started to not perform and in fact cut off on Mr. Jones. Mr. Jones had the vehicle inspected, investigated by another entity. That entity told him that he needed a new engine. There is also someone which basically is in the nature of a hearsay statement, but even if I take it into consideration, it says that there was an engine, strike that a rag that was left somewhere in the engine, and that may have contributed to the problem with the engine failure. The issue that is most critical in this case is what the parties' agreement is and what their behavior is consistent with that agreement. The agreement here is that I will pay you $2,500, which was paid to repair the engine and timing. That was noted on the document. The further agreement is that this repair, you can expect that it will last for 90 days. If it's the hope of all the parties is that it will last beyond 90 days, that this will be a permanent fix. But the agency, the defendant in this matter agreed that if this car went into disrepair during the 90-day period after the repair was done, that they would be obligated to in fact correct it. They'd be obligated to repair the vehicle. Their warranty by definition says that if it's beyond the 90-day period, that they're no longer obligated for the repair on the vehicle. Now, there are circumstances under which if a person engages in an intentional act of damage or in a grossly negligent act of damage, that those circumstances may make the warranty insignificant or make the warranty a non-issue. Here, the plaintiff claims that it was a rag that was in the engine that was left in the vehicle that caused the engine to fail, to experience failure. Well, if that were the case, the engine certainly would have experienced failure prior to the expiration of 4 months, because it is about 4 months out that Mr. Jones discovers that his engine is going bad. He discovers that there is a problem with the operation of the vehicle. That's 4 months later. There's no way that there is a instrument, towel, or anything left in the engine of a vehicle that is going to allow that vehicle to operate for 4 months before it goes out. That doesn't even make sense. That is not something that is reasonable. That if there is a towel or something left in the engine of the vehicle, that the vehicle would operate for 4 months without breaking down with a towel in the engine. How can that be? That's not possible, because the operation of a vehicle is a mechanical device that involves the turning of various components, and it involves the flowing of various fluids. It also involves compression. It involves exhaustion, and so on and so forth. And so the court would have to believe that a rag or some instrument was left in the engine of the vehicle, and that the vehicle was able to operate for 4 months without failure. And then all of a sudden, one day, 4 months later, the vehicle breaks down because there's a rag in the engine. That just doesn't make sense. What this is it's a very unfortunate situation, because both parties had an intent that was other than what the outcome was here. Mr. Jones wanted his vehicle repaired. He got it repaired. Mr. Quate wanted to repair the vehicle. He repaired the vehicle. Both parties wanted this repair to last until the vehicle wore out. That's what they did get. But the agreement is that it only has to work for 90 days. Because this is a 2009 vehicle, because at the time that the repair was made on the vehicle, you're already talking about a vehicle that's 12, 13 years old. Nobody is going to guarantee the vehicle for the life of the vehicle. Nobody's going to give a warranty for the life of a repair. 90 days is the time that is typically given as a warranty period for vehicles that are of this age. Having sat as a judge for it'll be 30 years in October, virtually that's all what I see is a 90-day guarantee. And that guarantee is what controls this case. That's what controls this case. Because there is a 90-day guarantee, and because the vehicle did not have the failure that is indicated here today until after the expiration of the 90 days, there is no remedy under this agreement. This agreement has come to an end. The repair was made, the payment was made, the vehicle performed for at least 90 days, and those are the requirements of the agreement. That's all this agreement provides for. There is nothing that the court can find beyond that on a claim that there is a rag in the engine that allows it to operate well for 4 months. But then at the end of 4 months, the vehicle then doesn't operate because there's a rag in it. If there's a rag in that engine, if there is some mechanical device in that engine where that engine is turning and moving and oil is flowing through it and all kind of other fluids are operating in the vehicle, you're either going to have immediate engine failure, certainly within 90 days, and or you're going to have a vehicle that catches on fire. Something miserably is going to go wrong, and it's not going to wait for 4 months. That's not possible. So my finding in this case is consistent with the agreement of the parties. And I already have acknowledged that it's something that's certainly unpleasant in this case. But that's the agreement that the parties have. My determination is based upon the parties' agreement that the $2,500 was paid for a repair that was to last at least 90 days. It lasted 90 days. After 90 days, there was a problem that resulted in engine failure, so on and so forth. That is not an obligation that rests on the lap of Transmatic Performance or Mr. Quates, and therefore my finding is for the defendant in this matter that the plaintiff has no cause of action, and therefore the case will be dismissed for the reasons that I've indicated on this record. I do wish both sides well. It's an unfortunate outcome. If this was going to happen, and obviously it would have been a great thing for it to happen in 60 days. But it looks like this happened somewhere at or near 120 days out, and there is no remedy left under the agreement of the parties because they had a 90-day warranty agreement on this particular repair. So I wish you well. That is my order. You'll get a copy of my order in the mail, and I do wish both sides well. Good day to both of you.